May be permitted to do an arbitration.
Why tomorrow?
Or for tomorrow.
Okay.
May figure the. I tried to read my on 18 months.
Huh? You filed a
Read petition, madam.
new matter. New matter.
Madam?
Is it a new matter?
Yes, madam, new matter. Day after tomorrow.
Okay. In respect to item number 104 and 105, bring for 3 weeks time to file a report. And for the respondent number 3 of the matter, they have taken the consequence of it.
Give me 104. This for the petitioner. Is this matter pertaining to clause 11? Clause 11.
But in the important note to be.
No, but there was an earlier writ petition, correct?
That is 104. No, there was 4 is the earlier, 105.
No, you see, what else? That 1068 of 2025, what about that? WPC 1068 of 2025, was it related to clause 11? There is another corrected matter, correct? We have filed another writ petition.
Not fair.
Not by you?
No, not fair.
Are you sure? One zero six six. 2025. Huh? 10%, no? 104. Same, that's what I said.
But that one is in relation to a different matter, not different.
You see, the issue is that could have a bearing in this case. So now you suddenly remember it, huh?
Right.
Mister,
W1 on behalf of Mr. Keegan.
huh?
Keegan.
Your name?
W Raman.
W. Raman, appearing on behalf of Mr. K. Karita, learned counsel for
Respondent number 3, important.
point number 3. What about the others?
Notice of petition. So, we're taking it down.
So let us wait. Why you in a hurry? You come at a time. Let us wait till in detail. Ask you for time now. What is the hurry? Yes.
And for the respondent number 5, we have been recently engaged in a file by developer. I'm paying for 4 weeks time, my lord, to allow us to police the file and assess this court.
Okay, right.
They are appealing pursuant to the service.
Yes, yes.
Now only after committing that a date will be fixed after that. It's a severe difficulty.
No hurry, no hurry. Yes, Miss
And thus,
M. Das appears on behalf of the respondent number 5.
Five.
And submits that she has submitted Bakalatama.
5, 5.
Submitted Bakalatama. She is accordingly granted 4 weeks time to file affidavit in a position. This is the matter of the proof.
Right.
Let's get it. No hurry.
Yes, in item 1 and 3, you just say tag this matter along with the WPC 2303 of 2020. Just in case we don't complete it. Just in case we don't finish it. That sentence has to be just the other.
The entire wheel was sketched, the head one. So, on last occasion, my lord, it's for I see the overview. So, the basic ground is that in every tender, there has to be a minimum percentage left below which no tender there. In this tender, there are nothing was mentioned. To what level they can go down or go up from the reserve price.
So is it a requirement that it should be there?
Yes.
Why? Where does the law provide you?
Certain manner, the quality of the work.
You see, Mr. Counsel, you have been in various cases, various departments have been asking for additional performance security. If they submit a abnormally low bid. What is the justification? You can do as you like. At times you ask for additional.
There are other things found that person, in order to get the fee, so that much higher price and it's not competing or much lower price
Correct,
and compromise with the quality.
correct.
So that's why then in PW also there is a criteria that nobody can quote below 10% of the reserve.
But then there are cases during this period only, where you have given the contract to bids which are 27% below the estimate cost. Then where is the argument? Cost flat on the face.
This case, no, the operation decided that that was required for the reserve for himself. My lord, it is also a certain position, my lord, that only because it's L1 my lord. Until and unless an order of what is issued by the what are the issued. So it is right for the.
That is there, but then there's another thing. You see, when you make everyone L1, everyone is going to give the same bid.
True. There is some.
Then you're going to pick and choose whoever is the most handsome guy or something like that.
There is technically some like a level of expectation. Here, my lord, what is the fact that actually that below my lord, in the result for the final for the case of 37, 34,
Which one?
there is an objection. If there is what happened, I lord 1.4, 1.3 and 1.4.
Yeah, it's here.
That can be done by the nothing.
Can always be done. You can always ask for justification. According to you, his bid is how much below the estimated cost? How much percentage below the estimated?
That inspector I know that. No? See the inspector, my lord, can you tell me that what is?
I am looking at this. Okay, this is
Yes, sir. The above reference understand is directly informing that after beginning of the tender application. One is by you, because observe that the evaluation criteria for accepting the plus minor purchases are not mentioned in the tender fee evaluation of the qualification criteria. Section 4 of the FTP completely also derived from the standard, deviates from the standard criteria in the LCD standard fee.
no, you have got to justify this. This is you are making a statement, and then you please look at this this notification of the governor. Wherein, if there is an abnormally low bid, then you ask for justification. Once the justification is found to be reasonable, then you have got the right to ask for additional performance guarantee.
In respect of this tender, it was a criteria to be embedded in the SPP. Tender to request for instance. That's why they have. I'll file it, it is not actually.
But then this is there.
Yes. I don't file it, not actually.
Yes, yes. Don't.
It's not a enter what we get.
Yes, it has to halt. It has to halt. Then, you see, when there's no work as on date, you have cancelled the tender. You have got to issue a fresh tender.
Yes.
So where's the question of work being halted? It has not started.
What I say, let's see, if anything done, maybe public outcome is public. It is also participate. Anything done in the meantime, will be public outcome.
You have to give a reason, a reply to. You cannot do as you like. heard Mr. D. Barwa, counsel for the petition. Mr. P. N. Goswami, learned additionally the here. Come. Mr. P. N. Goswami, author that he would like to file an affidavit with regard to the above. With regard to the reason for cancelling the tender notice, despite the petitioner being eligible. On the other hand, the petitioner's case, the respondents have time and again awarded contract work to those tenderers who have submitted abnormally low bids by asking for additional performance guarantee, and after having accepted the justification given for the low bid submitted by a tender. This is the matter. After the bid. Yes, wait for it. 21st of July. 21st July. In the meantime, the respondents are restrained from issuing a fresh tender to respect of the earlier tender. Okay. All right. You said 21st July. Then second.
One of the where here was the shifting of the workshop from one location to another. The application was duly made, NOCs were also submitted, reports were also submitted there. After that, the only form of the petitioner is that no final action or
No final decision.
let notice done.
You take a decision on his representation. That's all.
Hello, the time limit is fixed and
That should be.
that can be, we'll take it forward.
I take it for, right. First, Mr.
And so,
N. Chaudhary, learned counsel for the petition, who submits that the petitioner had applied for shifting of his IMFL offshore from Rangapara, ward number 3 to 2 number Dolabari, Testu, by application dated 25/6/2020. The petitioner submitted all the required no objection certificates as required under the standard type. And pursuant to the same, an inquiry report was submitted by the inspector of excise, Tezpur bracket Sadar, by letter dated 1/10/2020. Wherein what is the report?
but the report stated that as per the excise,
Page.
Madam, it was stated that under Rule 294A, Assam Excise examined the proposal with employers directed. In excise point of view, proposal of shifting of license premises from existing site to proposed site is potential and considerable if authorities.
That's neither here nor there. Separate inquiry report. That is potential and considerable. What does it mean?
Thereafter, another report was submitted wherein it was stated that it was found to conform to the.
Okay, right. The petition subject. That as the respondents were not taking a final decision on the petition's application, the petitioner submitted a representation dated 19/5/2025 to the Commissioner of Excise, praying for passing of appropriate orders with respect of the application for shifting of the IMFL officer.
At page 38, madam.
That case, madam, file. There is a document, my order is lying.
No,
Today being the first day, then I have question, madam, file.
I'm not relying on the order.
They cannot have.
I'm just stating a letter wherein it was mentioned.
Let the commissioner decide on his annexure.
Correct, that's all. Next para, the petition process subject that the writ petition can be disposed of if a direction is issued to the Commissioner of Excise to take a decision on the petitioner's application for transfer of its IMFL option.
Okay.
The location transfer of his IMFL. Next, Mr. P. N. Goswami, learned addition lady for a subject that he has got no objection to the prayer made by the petitioner. Next, in view of the consent of the parties, this petition is disposed of, come up with a direction to the Commissioner of Excise to take the decision on the petitioner's representation. The petitioner's application for location transfer of his IMFL offshore from so and so to so. The same should be done within a period of 1 month from the date of receipt of a copy of this order, which petition is accordingly to the rule. Keep yourself.
That is the pay 21 line. Right. Right. Then guarantee. Fine.
Madam, I think I don't see a case here. You have not even made the railways a party. No, it's not a question. There is your contract was terminated. There is an arbitration proceeding going on. And you go to the arbitration thing. No. You have got to first, you have got to show. This bank guarantee has been submitted by you to the railways. And you want that bank guarantee to be given back to you. Whatever. I do not know. Whether it has been encashed or not encashed, I do not know. I do not know. This issue is with the arbitrator right now. You go to the arbitrator. Let the arbitrator decide. No case, madam. There was
I'd like to play the agreement part by last page 20.
page 20.
Page 20. It is an agreement between the bank and the kind of petitioner. No, last. Notwithstanding anything contained here in our liability under this bank guarantee, I'm not expecting to change the bank. And for this bank guarantee shall be made up to 20 and
Madam, you,
the guaranteed amount. of
No.
25 year of
You-
the bank guarantee. We have to have a very positive. So they were bound to return my.
I do not know whether they are bound here. This is a railways matter.
Clause.
You have got to make railways a party. You make railways a party. Or, huh? You implead them and then you go to the arbitrator. If this court cannot decide this issue. You have not made the railways a party. This cannot be allowed. This and the earlier writ petition.
Asking for the amount.
Madam, you go there.
In fact, lots of the bank guarantee was revoked by them.
Yes,
It was invoked by the NFA.
it is invoked.
Honored.
Okay.
Yes. Before we could honor the bank guarantee, lots of petitioner approached the honorable court by filing the earlier.
But there was no stay.
There is no stay, but lots of it was related that encashment of bank guarantee will be subject to outcome of the writ petition.
So that was finished.
Thereafter, the writ petition was disposed of
Correct.
with a direction to approach the applicant authority that is a arbitrator.
Correct.
Now,
Yes,
GM.
whatever. You go there, madam. Where you have not made the railways a party also. This cannot. You see, one thing is, you see, it's your writ petition which is defective. Your writ petition is defective. When you want something to be, some order to be passed against the GM of the railway, then the railways has to be made a party. Because you said, madam, because you said that your representation to the GM has not been answered. So that should be your grievance. Then you make the GM Railways a party. No, please, I'm dismissing this representation, madam. No, I'm dismissing it. I'm dismissing it. This is not the way. Otherwise, you withdraw this, you file a proper writ petition with the railways as a party. No, no, not this way, no. I'm going to write down everything. Yes, you make a
I mean, they are allowed to go to the bus to fight.
with making a railway as a party. Right. Miss M. Sakya, learned counsel for the petitioner, says that she may be allowed to withdraw the writ petition with liberty to file a fresh after making the railway a party to the writ proceeding. Mr. He does appear for the railway, for the Canara Bank, and submit that though the railways had wanted to invoke the bank guarantee was not encashed due to the pendency of WPC 7215 of 2021, which was however disposed of uh, on a subsequent day. There was no day passed by this court in WPC 7215 of 2021. Huh? No, I'm just submitting his submission. Maybe, but I'm making submission so that I remember. No, this is a fact. The orders are here.
What is the order?
Yes, please read.
What is the order?
Please read.
Honorable Court, yes.
Please read.
First, my lord, is subject to the
Yes.
outcome of the litigation.
Correct, that is not a
The
interim
second,
order.
please. The second, my lord,
Yes,
everything, all further space to create has been
yes,
quoted, my lord.
yes,
Right of window to the application. Therefore, page 29, my lord,
yes,
in of the above,
yes,
in view of the above, has been found.
yes.
Note that to get the first, the children need to be cannot be offset without the advocate of the protect and have relief for education of our that to enlist for the bank guarantee and security. The effect of any such that it may be operating the responsibility as per the Indian interest agreement law. That's
Correct. So I'm just going to put this part, that's all.
and approach the future matters affect the article.
So we'll see. That's whatever I said. And WPC 7215 of 2021 was disposed of as follows. Page 29. From here to here. Next. The petitioner states that though the petitioner submitted a representation to the authorities in the NF Railways, no decision has been made by them. In terms of the order passed in WPC 7215 of 2021. As the petitioner's counsel has paid for withdrawing the writ petition, the writ petition has withdrawn, with liberty as well. Withdrawn, dismissed as withdrawn. You said you wanted to withdraw.
So many
No, it's not unmerited. I'm just saying the facts of the case.
observations.
I'm just saying the facts of the case. No, sorry, I can, no. You can go to the division bench and say that. Yes, next.
Filed on the last petition, there was a direction filed to the Director General CID.
This is item number? Hundred. Yes,
That report from the.
yes, yes, yes.
It is come by. The pointed questions raised by my pilot, the CIT has gone into.
So, so then,
So my lord, the next even wrote a letter to the CIT, my lord,
ah,
second last page, my lord.
again, last page, okay, yeah. Yes.
My lord, the diplomacy, my lord.
This is by National Education Society for Private.
They are the one, my lord, who authorized, my lord, who answers to the procedure. They say National Education Society of Tribal Education did not appoint any principal for CMS or a Kalbari Baksa, district Assam. NEST has not authorized any NGO to run the affairs of the school Kalbari. In the report, pilot even DC says, DC is not aware how they have come into. The principal secretary says, pilot of the department, principal secretary given the January, said, they, my lord, while the building was under construction, they forcefully, my lord, they encroached upon the thing, they entered, and they are trying to run a school in the name, which is, my lord, has nothing to do with
Cheating.
yes, it's a cheating, my lord. My lord, it's a cheating, and my lord, they are playing the future of the children's life. That is the thing, my lord. But once, my lord, the nest takes over, everything will accommodation, my lord, there.
I know, everything.
My lord, the biggest thing is that the principal, when they visited, he was on the run. He was not there. It was a single document that he was he's been receiving salary from the government.
Let a case of cheating be registered against the government.
There is it's a gross cheating, my lord. But before
So
the
I will be allowed to file one ethical affidavit and just metamorphosis either on faster or Friday law. No, what? This important Lakshmi. Lakshmi, this school was established under the guidelines of 2013. Mr. Council, did you construct the school? No, Lakshmi. No, Lakshmi. What is your right to be in the school? Okay, only was the 2 days. And later will be hired on Thursday. I have every document records. Lakshmi. Yeah, that's it. In the meantime, let a case be registered also. Then you can file also.
This is very important, my lord. If there are cases registered, he is issuing your lordship. He is a, my lord, he is not a principal. Nobody appointed him, but he is signing a document claiming to be the principal of that school, my lord.
And using that school as his school.
School as its own, my lord.
He's some big gunda or something around there or something. No, we'll give you time to file affidavit, but in the meantime, let a criminal case be registered and the investigation be done. Huh? Copy of report. Yes, give it to him. Have you got, you don't have any other copy?
I have the photocopy. I will give.
Right. Right, Mr. H. Talukdar, Learned Counsel for the petition. Mr. R. Bhatt, Learned Counsel for
Additional senior cover.
the additional senior governor. Mr. Abdul Rahman appears for fund number 5. Who are you? Who's this fund number 5?
I read that corporation group was a job to build the boundary wall.
Number 5. Yes, anything to say? Right. The petitioner's counsel shall serve a copy of the writ petition to Mr. W. Raman, counsel for the respond number 5, during the course of the day. Right. The Eklavya Model Residential School, represented by its alleged principal, Shri Angelus Baxla, has paid for alteration slash modification of the administrative approval accorded to her. The estimate prepared and submitted by the respondent number 5, in relation to the construction of a boundary wall for the said school. Next. Mr. Arthur, Learned Counsel for the respondent number. Please submit that the principal of the submit that the petitioner who is running the Eklavya Model Residential School is a fraud and he has not been appointed by the National Education Society for Tribal Students. Bracket NIST. This court on 13/6/25 had recorded the fact that the Eklavya Model Residential School had been constructed under the centrally sponsored scheme, to be managed by the National Education Society for Tribal Students. Bracket NEST, which is an autonomous organization under the Ministry of Tribal Affairs, Government of India. The said school was thus to be managed by NEST, as it was constructed through the Tribal Affairs Department under the Government of Assam. Next part. The petitioner in the writ petition has claimed that he has been appointed as principal of the said school by the managing committee of the Bodoland Model Tribal Education Society by letter of engagement dated 28/6/2013. The said letter dated 28/6/2013 was made a part of the record and marked as an exhibit. Next part. As there was nothing to show that the petitioner had been appointed, as there's nothing to show that Sri Angelus Baxla, PAX, who had stated that who was supposedly the principal of the Eklavya Model Residential School. Dalpari. had been appointed by NEST in the STA, comma. This court had impeded the Bodoland Model Tribal Education Society, comma, the special DGP CID assigned Gulubari and the Superintendent of Police Pakta as respondent number 9 to this. This court, by order dated 13/6/25, had also directed the special DGP CID assigned and that or the Superintendent of Police Pakta to make a preliminary report with regard to whether the said principal of the Eklavya Model Residential School Dalbari had been appointed by NET and whether the Bodoland Model Tribal Education Society has been given any authorization by the by NEST to run the affairs of the city. The the SSP Crime Against Women and Children, that was CID-SM, has submitted an inquiry report dated 21/6/25 in pursuant to the order of the court. Wherein it is seen that wherein it has been stated that NEST did not appoint any principal for EMRS Dalbari and NEST had not authorized any NGO to run the affairs of the EMRS Dalbari. A close reading of the letter dated 21/6/25 issued by the SSP Crime Against Women that shows that the petition that she has been running the EMRS Dalbari as his own school and has been imparting education to children by taking fees from them on a school that has been constructed by the Tribal Affairs Department under the government. The next one. Mr. R. Dhar has also no R Dhar. Adhar has also submitted letter dated 18/6/2025 issued by NEST, which states as follows, which states that NEST did not appoint any principal for EMRS Dalbari and had not has also submitted letter dated 18/6/2025 in line with the report of the SSP.
Dia examine those Ramakanta Mutahari, that's number 9. Model society. They even propose any document if they are
One more thing. The report of the SSP also shows that the Bodo Land Model Education Society, which had apparently appointed the petitioner as principal of the EMRS, had not been able to produce any document any document from the Ministry of Tribal Affairs, Government of India or Government of Assam regarding the fact that they had been authorized by NEST to run the affairs of the state. The above appears to the above report prima facie shows that there has been that the said school is being run by an unauthorized person, and that a case of cheating may be made out in view of the said school having enrolled students and taking classes in exchange of fees. In this respect, this court is of the view that a criminal case should be registered to go thoroughly into the facts of the issue as to whether the said school run by illegally alleged no, run illegally by so and so and Angelus Bakta has been taking fees from students without being authorized to run the same. Who do I direct? That is point number 10. Number 10. Huh?
The CID management, they have to even communicate with NEST.
The point number 10 is accordingly directed as point number 10 or 11. Who was to be?
Find out. No, man. CID.
Yeah, the point number 10 is accordingly directed. Register a case against the petition school currently run by an unauthorized person. That is so Baksa to ascertain whether a case of cheating has been made up by unauthorizedly running the EMRS and taking fees from children by giving the impression that he has been authorizedly, he has been given the valid authorization to run the test. In parallel, this is the matter on after vacation date. Second, in the meantime, the petitioner, in the meantime, yes, I think you should appear also before this court. In the meantime, the petitioner may file an additional affidavit. The Shri so and so Baksa shall also appear before this court on 25th July. A copy of the
My lord, I'm just heading over there. My lord, yes, sir. What my lord has stated, the report, the first letter I'm not giving very five.
correct.
The report of the CID and the letter from the next.
The report of the SSPCID and the letter issued by NEXT has been handed over to the petitioner's office today. You bring that Patla on 25th.
Meantime, my lord, get arrested.
That is why I want him here, so he gets arrested. No, no, acha. In the meantime, you mean? Okay, cut that part. Cut that part that it should appear on this thing. Cut that part. It did not appear. My camera. Item?
Item 101.
Yes, what are you challenging?
I have been told the NIP, that is suggested 2025, 2022.
Yes, which?
Yes, 15 million.
Yes. You're challenging which provision?
The first the provision of 12, 13, 4, 17, and 22. 12, 13, 4, 16 million, 17, and 22.
13. Okay.
13,
I think you, is there a gazette notification
Yes,
now?
gazette. Before that, it is gazette. On 9th of April, it is yes, I have it.
Yes, yes. Now let us see. With regard to 12. 12 limits the tender to 10%.
Yes.
So where is that 10% here?
That is rule 47, 1, second page.
Rule 47, 1. Okay. So this challenge to 12 goes.
Yes.
Correct.
Yes.
Then let's go to 13 car.
I think so.
What is this car?
Oh, but with the Assamese,
Oh, 13 is car is 13.
for
Oh, oh, 13. Okay.
if more than one local tender or public tender at the same tender bill for settlement of any part, and if your tender found applicable for 20% as per terms and conditions of the tender duty, then an eligible bidder will be selected among the local tenderer for settlement of their part go slaughter.
What? If more than one local surface tender. And an eligible tender.
Your lordship, if there is I,
Ah.
fulfilling all the conditions, your lordship, if their tender value is
Same.
then it will be decided for local.
Okay. Then what kind of translation is this? An ineligible bidder will be selected.
Eligible bidder. Eligible.
You have that's what I asked you, what is this? Eligible tenderer will be. Okay, so where is this?
Because
Where is this? Is this here in the thing?
No, not in the rule of.
Okay, so it is with true lottery. So what is wrong?
then it is wrong in terms of clause 10 of the rule 47 of the financial bill.
Assam Panchayat.
Yes. Financial bill.
Clause 4710. Yes.
The tender of highest bidder can be accepted. Acceptance of tender other than the highest bid can declare the foreman forever and forever. It says that the tender of the highest bidder.
If there are two highest bidders, then if there are three highest bidders, then
But the authority cannot take the highest bid. It is that more than only 10% more than the 3 years, last 3 years about a settlement. What? That is close 10 million or 12 million.
12.
12.
That's it.
In case of all hard tender of the highest bidder shall be accepted for possession who submit tender within the limit of 10% of the average 3-year settlement value.
Correct. Okay.
If
What they are trying to say is that they cannot limit that they cannot limit that 10%.
Yes.
10%.
then below the
Just a minute. But just let me see. You see, this notification is an amendment to the rule.
yes,
So the rule has been amended.
that is there.
What do you mean that is there?
The amendment is there.
Let us see the amendment. Where is that amendment? So it says, draft rule 1 has been amended.
Thus, hard law
Huh?
the use of fisheries are formed as are vested in for use under the control of the Supreme Court Consent, Chapter 105, 108, and until time of council consent of the Act shall be settled by inviting sealed tenders effective for 3 terms for trust amount not exceeding 10% of the average settled below of the last 3 years for the respective half which there is on effect. That is why nobody can submit tender access to the 10% of the last 3 years of the average settlement. Then, the post should be 2 million. The
Yes.
lessee should deposit 100% settlement in the office of the Jilla Parishad within 1 week from the date of issuance of notice of settlement. If that be so, there is no provision that the lessee should deposit the settlement and the settlement within 1 week.
Is there any bar? Is there any bar in the rule?
Because
No, Mr. Counsel, it's not a question of because. It's a simple question. Now the terms and conditions require that 100% should be deposited.
within 1 week.
Is there any bar in the rule that 100% cannot be deposited?
Absolutely, there is no bar.
Then?
But then clause 17 comes
17.
if he has been deposited the entire money within 1 week, then why the grant of is less than 5 years?
Huh?
Grant of close 17 million. The tenderer and his grantor should enclose the claim certificate, particular claim certificate of the partner. Then if lessee has to deposit the entire money within 1 week, then my assumption is not the grantor must be. And for most all the Jilla Parishad, the city.
Okay, so they will not insist for guarantor. That's all. But if they're submitting 100%, where is the requirement of guarantee?
Guarantor is not necessary. Then
Because everything is secured.
then as per the decision, the state executive officer has no power of issue of the NIT
Where he will need to know.
officer. Then the rule 47(1)(2). Position 1(2). Provides the closing of tender at least 45 days before the last day of contract. Yeah. Thank you.
As per rule,
47 close to
45 days.
45.
Then how many days?
Well, in this case, not 18 days. And it is impossible to collect all the necessary. And now I refer to students that is 100% skills.
with regard to?
Regarding the power of the issuing of NIP, and the authority has no power fixing the highest bid.
Well,
That time it was,
I know that time was rule, that is prior to the amendment of the rule.
but the power of the security officer,
Huh?
power of the security officer has not been amended as on date.
Where is the power of the, where is the power, who is to issue the NIT?
It is the president of the Anklit Panchayat.
Where is this in the rule?
Section 105,
105.
and it is confirmed by the letter. 105.
105 of the act.
Yes. Then the authority cannot keep the high standard with documentally through the paragraph 20 or the presentation. Yeah, I think
That was prior to the judge, prior to the,
that these these are for arguing more problem with it.
that is their problem.
The problem is there because suppose
You have to challenge the rules, Mr. Counselor.
yes, we have to
You have to challenge the rules.
as on date
As on date, the rules are enforced, the amended rules are enforced.
are enforced. But the president
The other,
power
yeah.
45 days.
Okay, the other provisions you see, but with regard to this 10% and all that, you have to challenge the rules.
That is better. And if they permit us to submit a writ tender, then at least 30 days time may be allowed to. Otherwise,
If the rule says 45 days, it should be 45 days.
45.
Why should it be 30?
The Kenya filing representation before the authority for example. So we will keep which provides for 45.
So for 45 days, that is one. Now, what about the NIT being issued by the CEO? It has to be by the president of the Challenge Panchayat.
So the following the at that time.
Huh?
At that time, you will keep the unit.
Mr. Counsel, what can I do?
How you know
This is the-
you to establish how they are agreed.
No, this is the law, Mr. Counsel. This is not a question of, this is the law laid down by you. It is not a question of principles of natural justice or something like that. This is a statutory law laid down by you. You have made the law.
Okay.
Unless he will say that, okay, I give up my prayer. I cannot. I can. You see, I cannot say that you have to disobey the law. How can I say? You,
Because they might and I think
you see, it says here very clearly. By inviting tenders at the office of the Anchalik Panchayat by its president. Clear? By its president. Doesn't say by its CEO or something. By its president. And at the office of the Anchalik Panchayat by its president.
at the time the president was not doing that. But if you say if you're also to leave the exam, because
Then I'll have to say
deviation is
everything.
there,
Huh?
because if deviation is there. If deviation is there.
Mr. Counsel, this is not a
that
term.
the object of the act and this particular provision of the.
Mr. Counsel, this is an act. This is not a, your terms and conditions are governed by the act. If he can, if he says that he is not pressing this prayer, then I can overlook it maybe. But you have to give that 45 days time. So I do not know. You all have a chit chat outside the court and you all tell me later on if you all want. But if he's pressing it, then the entire NIT will have to go. What to do?
We are agreed to for achieve. Now it will gone again for 5 days.
Correct. But what to
They
do?
will suffer.
What to do, Mr. Counselor?
At that time, that was issue was not aware that last year February itself, the budget was earlier. You, as per my knowledge, my lord, the oath ceremony is next, my lord.
I don't know.
So the CEO was the my lord, acting member.
I don't.
He has the power.
I don't.
He has the power.
Show me. Show me that he has the power. Show me.
For that, I picked up.
For and
Because
until the time you take instruction, I'm saying everything.
in the absence of the
And till the time you take instruction, I'm saying everything.
that will happen everyone might.
What to do? You talk to him. Yes. Are you want? Do you want that we extend the time? We'll extend the time.
But Malata, I am Malata challenging the NIT on the grounds of 45 days and the power. And
On the ground of
one market, right? Not
on the ground of
Malata, that is 45 days growth and the power of the chief executives. And Malata, I am Malata only for one market.
so far we'll give you 30 days, but then you'll have to overlook that CEO part. Yes, but that with regard to the other trails that cannot be allowed because of this act, amended act.
But it is Malata confirmed by the Minister.
Full bench decision is prior to the amendment.
But the amendment of the Contract Act has not been met. These are only the contract amendment has been act also.
Assam Panchayat Amendment Act 2025.
I have the bill, but I have not the
This is the act.
I have the bill.
This is the act.
1 minute, 1 or 2 minutes, I have to start from the Pagat, I think we can have into the fact of so only 2 minutes.
Yes. After some time. You take it up. Yes, I think your case goes. Okay. I think he's going to have an uphill task. He's going to try and climb Mount Everest.
The 45 days programs of that is a nice topic.
Yeah, you know, your case is different. Your case is against the executive inspection. It is not against any NIT. It's different. Slightly different.
Reflected everything in NIT. That is no worry.
Huh? Huh? Okay.
My lord, similar to the previous one, my lord. In a notification, I didn't find any restricting local residency.
I'll tell you fine. There was the amendment officer.
The amendment will challenge it, my lord, but local residency is not there. Now they are saying that one has to be local resident. That is not there.
Yes.
There.
Yeah.
Yeah.
You look at is number 3 of the is number 3.
Where?
20 or
Yes.
will also pay.
Yes, yes, it's 5-6.
Yes.
Well, we'll have to challenge the
You'll
notification.
have to challenge.
Challenge.
For the assets settled at Gaon Panchayat, the lessee shall be from the concerned Gaon Panchayat locality.
That's all right. We'll have to challenge the notification, man.
And you withdraw this.
I
Or
think
you
so.
want
We
me to
should do.
dispose of. I can dispose of also if you want.
Mala, I think we should withdraw it, but I'll have to talk to my learned
No,
friend.
you
Mala,
withdraw.
discuss.
No point wasting time.
Yes,
It's
yes,
there
I
right in front of
understand
you.
that.
The act has been challenged. The act has been
Yes, I
amended.
understand.
The financial.
Yes, there is a total amendment is there. We'll
yes,
have to
the
challenge
financial amendment rules
that.
has been
Yes.
amended.
Yes, I understand that.
Nothing remains.
And we'll have to challenge it in before division bench.
Yes, yes. Before division bench. Luckily for me, I don't have to go through all the hard work. Okay, right. So you withdraw,
My lord, yes, I think so.
Mr. PD.
With liberty.
Yes, yes. No, what liberty? This is a challenge. You go
Yeah.
there. Who am I to give you liberty
Yes.
to go to
No,
jail?
in view of the, it has become infructuous.
Yes,
my
yes.
lord.
I have said that. Yes. Mr. PD Das, Leonard Senior Counsel, assisted by Mr. S.C. Biswas, appears for the petition. Mr. K. Kowar, the learned additional advocate general, Assam, appears for the respondent. The petitioner has put to challenge the
Executive order, man.
has put to challenge clauses 1, 3, and 6 of the impugned executive instructions dated 20/05/2025 on the ground that the said clauses are illegal and unconstitutional. On the other hand, Mr. K. Kowar has submitted that there has been amendment of the clauses that have been put to challenge by the petitioner, while the Assam Panchayat Financial Amendment Rules 2025 and the Assam Panchayat Bracket Amendment Act 2020. Mr. Leader submit that in view of the above submission made by the council for the by the another additional lady, he would like to withdraw the writ petition with liberty to make a challenge to the Assam Panchayat Bracket Financial Bracket Amendment Rules 2025 and the Assam Panchayat Bracket Amendment Act 20. The prayer of the petition process is allowed. The writ petition is dismissed as withdrawn. Oh, no, dismissed as withdrawn.
Why are you permitted to?
Okay, this. Yeah?
I've got a copy. I've got it.
Huh? You've got a copy?
I've got a copy.
Huh?
I've got a copy, yes.
You want a copy? You got a
No,
copy?
I got a copy, man.
You got a copy. You got a copy.
Disposed of, my lord.
Okay, disposed of as withdrawn.
Obliged.
I will also dispose of. Wait. Okay, right. Okay, right. Third, Mr. D. Kayyum, Learned Counsel for the petitioner. And Mr. K. Kowar, Learned Additional AG Assam. After considering the submissions of the counsel for the parties, Mr. D. A. Kayyum has submitted that so long as the respondent give how much time? 30 days time to submit bids pursuant to the NIT dated 7/6/2025.
From 7/6 to 45. I am not getting from the first July.
So you want 45 days bid?
Yes.
Okay. What about that? 45 days time to file their bid, to submit their bid in pursuant to the NIT dated 7/6/2025 for, for submitting and, for which market?
मतलब it is मतलब the Palishatra bi-weekly market. Yes, मतलब 12.
For the Bali Satra bi-weekly market. You would not like to press the other point raised by him in the recording. Submit the case for what the additional, if he submits that, he does not have any objection to the prayer made by the petitioner's counsel, and as such, the petitioner and other bidders can submit their bid on or before 45 days will be.
45 days will be on by
This is July 20. Or will be 45 days.
but this year you will actually is asking for only 5 days.
No,
And I said, oh, not that.
first July 30 days.
Yes.
Okay, whatever I said from the beginning, huh? It gives 30 days time. With effect from 1st July, no, 30 days time with effect from 1st July 2025 for submitting the bids and comma. You would not like to press this other. Okay. If the case was, they can legally submit and they will not take it.
If the 30 days is counted from 1st of July, it will exceed the 45 days.
Oh, yes. It will exceed 45 days. It cannot exceed 45. When will it end?
It was issued on 7/6.
When will it end? 45 days? Which date will it end? Which date will it end?
You will achieve on 20th of July.
20. So we will make it 20 days, Mr. Council. 20 days from 1st July. Ah, for 20 days. Instead of 30 days, make it 20 days from 1st. Okay. On or before 20th July.
It will be about 22, 45 days from 7/6.
Okay, make it 22 days.
Yes,
22. Uh, to 22nd July 2025. In respect of the market, that in respect of the Bali Satra bi-weekly market only.
So far, the next one 25 seat. It will be able to 35 or 35.
What 25 things?
The NIT is 125 last day of
Consequently, consequently, the last day for submission of bid as,
just 15.
huh?
Just 15.
As has been stated in the tender notice. Last date of submission bid. When is the date?
Just 15. Second paragraph under the tender will be accepted.
Whatever accepted this. Comma, that is 25/6/2025. Shall now have to be read as 22/7/2025 in respect of Bali Satra bi-weekly market only. The writ petition is accordingly disposed.
Okay. All right.
No, what about the other? Let's finish up the rest first. Then we'll take yours now.
Considering the office code tickets must comply to the order and we have participated cost. As again, also we are going to find the ticket in the course of the day. We will serve a copy there.
Yes, we have served a copy.
This is not, it's a, we will serve because we already office ready, we will serve.
Are you filing today?
Yes, Lord.
Okay, Mr.
I said up here. This is
S.A. Bhakhtiar, Learners Council for the petition. Response number 3, submit that. The cost of rupees 10,000
10,000.
has been paid, has been paid today. And
28 of June.
Has been paid on 20th June,
26.
28/6/2025. And that the affidavit will be filed during the course of the day. Correct?
Yes, sir. We will of course, but we will.
Course of the
In
day.
the, before the second half of the day.
Okay, then when this is the matter after vacation, you will have to read the affidavit. also.
That is a lot, sir. After publication. Lots of, the date is.
It will not take time because the appeal for regulation has also been rejected by the.
Okay, list the matter on Wednesday, after tomorrow.
Lots of papers, lots of papers after vacation.
No, I want to see whether you file it or not. If you don't file, then
We are going, we are complaining with them.
we'll see Wednesday. Or Thursday, list the matter on Thursday. Thursday,
Or the processing paper, 20, lots of 20.
20. We'll see.
Because
Yes.
CMC council has just to submit.
Yes, sir, yes, sir, we will.
We will see, Mr. Council. Yes.
The order of the chain.
Yeah, something like that. Not so bad.
Lordship, we are finding our affidavit today. We'll discuss it later.
Mr. R.R. Rohit submits that affidavit will be filed on behalf of the Excise Department today.
Yes, sir.
Have you given a copy?
Now we'll give him a copy.
This is the matter after vacation. Give it in.
I will find it.
I for one. Imprisonment. Okay, when they, why? They want to be imprisoned, what is wrong?
Whether they focus about. Because we have cleared the rescue, very, very.
How are you going to object?
Yes. They find operation for the.
Okay, fine, it's not objection. Mr. I right. Heard Mr. R. Bora, the counsel for the applicant, to praise that the applicants are resident within the prohibited distance from the proposed new location of the White House, of the writ petition. It submits that the objection against the proposal to relocate the petitioner's White House has not been considered by the Excise Department. As put up as such, the application should be impeded in the written as respondent number 6 and 7. Mr. N. Chaudhary, appearing for the writ petitioner, is granted 3 weeks time to file a written objection. This is the matter after the meeting.
Otherwise, not.
It is fine. And 81 also. 82, give me 82. Yes, who is for the respondent? You asked us here earlier. The police, for the police. Director General of Police, Kamrup Metro Commissioner of Police. With the take over, balance counsel appearing for the response number 1, 3 to 6. Is granted 3 weeks time to file affidavit in voice. This is a matter of the 3 weeks. Yes.
87 was it 96 similar minor after both where got the patent documents from the extent of
Mr. K. Gogoi appearing for 120 and Mr. for Industries and Commerce Department are granted 4 weeks time to file affidavit. This is a matter of the court.
87 to 96.
Huh?
87 to 96.
87 to 96. This is a common order. Common. 87 to 96. Yes, Data. It is for PNRD department. We wait for some time. Like,
Time it is the respondent for one. Your authorities are taking up the process for complying with the directions passed by the Honorable Court related to by the non-payment of fees for materials supplied by the petitioner. So it will be done by the time seeking a recognition of the requirement. Next one is the order of is for the they are when they have taken time at the time of passing the judgment. Because clearly that the order nothing like that. They have because thinking about the matter. No, but it is not a fact matter. It is not that we are checking. Then it is the relevant of the state. So it is done matter because some particulars were not forthcoming from the district commissioner of this matter. We have sought for it. We can receive everything. It is now our responsibility. It has to. There is no way of accepting it. And taking an accommodation of this. If after 3 weeks, madam, I think it's forthcoming. Not to be first week on. I'm not here for citing any affidavit, madam, and for delaying the record. But we are here to comply. With kindly accommodation.
Mr. R. Borpujari, Senate Council for the respondent.
Respondent number 1, madam.
1. Submit that the process for compliance of the order is ongoing and the order will be complied. It submits that he has got no excuses to make except to pray for time to comply with the order. Accordingly, leave this matter on your attention.
And so, President.
No one appears for the review petition. The interest of justice is the matter after the petition. There's no case act, in fact. Right. No one appears for the petitioner. Office note indicates that notice was issued to the respondents number 4 to 7 on 10/6/2025. await service report. This is the matter after the debate. Yes. You wanted to file a affidavit? Yes. Your earlier in petition 1068.
It is not because the next petition making it a policy. And after you got a model that happened, they the best filter, the best filter you must be doing for the
Okay, Mr.
W. Raman on behalf of Ketan.
W. Raman, appearing on behalf of Mr.
Ketan.
K. Kalita.
For the response.
For the point number 3, is granted 3 weeks time to file affidavit. This is the matter of the three. Same order. This is a timing matter.
Timing item 97.
Yes. We want Mr. S. Datta. He was supposed to give that verification report. He is not here. Submit the affidavit. Okay, we'll take it up at 2. 2. Okay, take it up at 2. Call the council, Mr. Datta. Including 1, 2, everything. All the. Where are the happened? Mr. Arada here. The government of India was not represented. So, this thing has to be discussion on this particular party. So, there now bargaining up with them and parents.
There is 92.315 crores as separate. In fact, the state has paid more than what is our share. To comply with the quota, it's up to your question. Our liability was 21 crores, we have paid 24 crores. Comply with the
Yes, let us ask the, yeah, department technical. He's from which department?
what is
Yes. What are you? Please tell us about the background and what is the present situation, present position.
Actually, within 41 skills were approved, the participation program by Dr. India using 11th plan and 12th plan.
Just a minute. Okay, then
That skills were recommended during 11th plan, 41 skills were recommended in 12th plan.
41 schemes under 12th plan.
In 12th. So out of the 11th plan scheme, there were particular 17 schemes. They were recommended during the last financial year of 11th. And the cost as approved by the Water Resources was less than the cost approved by the planning from Central Water Commission and our administrative approval of the state. So there is a lapse of rupees 1149 crores, but the disbursement exceeded the work for the whole amount.
The works was 140 crores less.
The total cost of the scheme for 17 schemes as recommended by the Central Water Commission and Planning Commission administrative approval was 341 crores.
Okay.
But the schemes were recommended in the last financial year of 11th plan. So they categorize the schemes as spilling over to next plan.
Last financial year of 11th plan.
Yeah.
So
They categorize the scheme as spilling over the next financial year. But they only recommended the amount that was meant for the 11th year. That is the last financial year of 11th. The cost was approved by within 90. 191.
So no, so right now we are only concerned with those 17 schemes.
Yeah.
Correct. So those 17 schemes, the cost was 341 crore. Now, what is the ratio, the share ratio of the state and the center? 90-10 or 80-20?
90-10, subsequently it was revised to 80-20 after March 2015.
March 2015.
Initially it was 90-10.
80-20. Now, out of this amount, how much has the state released? Has it released its 20% share? 10%, 20% share, has it released?
As per the cost approved by the Water Resources for 11th plan, the entire state share amount has been released.
As per?
As per 80-20, 90-10 and 80-20. But the amount for which there was no any approval from the Government of India.
You say water resource. Jal Shakti water resource, same thing.
It was previously it was Ministry of Water Resources, Now it is municipal also.
Yeah, so same thing.
Yes, yes.
So according to that, state share has been paid
Yeah.
for the 17 scheme. Now for the 17 scheme, how much is still to be paid by the center?
As per the administrative approval cost, is about 92 crores. It is the statement, for extent
92,
92.315.
315, 315 or 3152,
315.
3154,
2.315.
92.315. So have to be still released for that 17 scheme. So that much has not been. Now where is the bottleneck? Why are they not releasing?
So we have submitted the proposal.
You don't know why. So all these 17 schemes pertain to the 11th plan, not the 12th plan. And this scheme, the 17 scheme, they were being carried out which year? The last of this contract work was completed which year?
15.
2015. What about the 12 plan schemes? They are all there's no problem.
Yes, right.
Okay.
Last month also.
And the cases that we have here today, these are all pertaining to the 11th plan, all the 17 schemes. So now, that is the basic thing. Anything else you have got to tell me? You want to tell me anything else? How much did the state release the amount can you give me in black and white the amount state share release?
Against the 17th scheme, the state share release is 45.96 crores.
45.96 crore. And center has released
130.4.
130.441.
41.
175. 175, 176.33. Okay. 37. 176.37. And the total thing is 341.
41 crore was the administrative approval amount. These schemes were foreclosed in this book. So ultimately,
These schemes were foreclosed out of the 14,
out of 70.
out of 17. So is there any use with respect to this foreclosed scheme?
These schemes were closed due to land problem.
Due to?
Land acquisition problem.
Ah.
And one scheme was closed as it was on the periphery of the Manas National Park. So it was closed by green tribunal.
My question is there any claim right now being made with respect to the foreclosed scheme?
So the foreclosed scheme order for two schemes which were proposed due to land acquisition for them, there is no any pending contested picture. And for the scheme which was closed by the green tribunal, there is a amount of 1.98 crore rupees received from the. And we have already submitted the proposal in the last.
Yes, I think, anything else to tell me?
However, in prepared approved by the Minister of Water Resources for 191 crore. State government has already released the full amount and they are there, therefore about
But where do you get that 191 crores? Because you said that 17 schemes were for 341 crores.
192 was approved by the Minister of Water Resources.
And, okay, 191 crores,
Was approved by Minister of Water Resources for the portion that can be executed during 11 steps.
but what about the 341? 341 is only administrative approval.
State approval and Central Water Commission approval and Standing Commission approval.
But then the Water Resource Ministry approved only 191 out of the 341. So we cannot claim, so, okay,
But
so,
the executed for the full amount.
you know, for the full amount, to be
because
paid by who?
the
Beyond the 191, who will pay?
The schemes were actually approved technically by Central Water Commission.
But then when the final approval has been given for only 191, they will say that why should we pay beyond 191?
They categorize the scheme with spilling over to next financial year.
They categorize,
Yeah.
but they categorize only with respect to 191.
They categorize all the 17 schemes with cost 341 crore
Spilling over.
as spilling over to next year and recommended only like 91 crore for that.
For the last year of the financial year, last financial year. Is it? For the last financial year after the 11th plan. I don't know, why not the minus plus minus? Sir,
Yes. Is the following were the main points. There are one of us.
anything else? No. Have a speak. Yes, yeah. Okay. But you see, one thing they have said is that though administrative approval have been given for 191 crores, correct? Huh? 341. And for final approval given for 191 by the Water Resource Ministry. The entire 17 schemes were categorized as spilling over to the next financial year. Financial year or financial plan? To the next financial year. Or to the next plan, for what? So it goes to the next plan. So not financial year, goes to the next plan. So you see, when it goes to the next plan, so under the 12th plan, it takes care. So maybe 191 crores was for the 11th plan. And the 341, 340 minus the 191 would spill over to the 12th plan. The rest, the rest the money.
That's the money, kid money. So, I have the advice, how much dedicated select one I have.
How much? According to you?
For one of the technical function, I'll be discussing on that kind of because that part might be that not my team wide college also. Can you take a day of this to for one of the technical function and also taking with the state government budget. Yes, one day I did it. I'll see that water some of the both kind of and I'll go through all batch and how the balance.
I'll tell you one thing that can be done since he wants time. You'll call a technical person. Mr. Uwe, let him, he also sit with them. Let them thrash it out. And then we meet again when? On Thursday.
By 2 o'clock, they will do whatever. What, 5, 6, 7. That's why what.
On the basis of their margin, part of it also discuss on their margin, on the basis of their margin also. And also our kind of keep selling on what we have.
You must pack it out because it appears that there is money.
There is a that is not there is a fair part.
If there is money, why you not?
Because
Then why you not releasing?
when a get to some on the government and something they are to take in my second these there are also another thing also not only one
Audit objection from where?
complication
From the state audit.
check central audit of
From the central, not from the state. He representing the state. Oh, you're the bottleneck.
Last time. We didn't want it. That is good. And perhaps we'll also cover the other.
It should.
It is because they'll also will kindly see what are the issues for page 50. I have quantified last page.
Yes.
And these are the reasons for your lordship took note of that. And para 5, 6, and 7 million is what we are saying that we are not either paying nor again. We only say that we take a look at the data. If they are correct, we recommend. Beyond that, they are not. Para 5 and 6 and 7. Page 49.
Yes.
I think submitted to the argument of quantum being a audit for being completed a recommendatory capacity. Doing the audit of the provide all approximate looking at the person body key to audit paragraph or object and comments reply the short form of the audit. If the reply is found satisfactory, the official stop. In the cases, that is, in the cases where the reply is not found satisfactory, the answering respondent may recommend remedial action to the audit. However, the answering respondent does not possess any power or authority to enforce the certificate. The responsibility to take further steps lies only with the auditing department or its consulting ministry or authority. The respondent has no power to compel any action beyond raising the auditing. So far as petition is concerned, my lord, so far as against AG there is no claim. AG has been made a party, but there is no claim against accountant. Has been made a party, but there is no claim.
It can be. Having got all the claims of the petitioner.
My lord, I am, it's not a 250. So far as 250 I can. Other petition also they are 80 days, perhaps by other companies. So,
So with the three petitions that you have, is there any objection to the
well, this is the objective which we have gotten pursuant to the academic file of the petition.
That's all right. That is the basic generalized
Yes,
question.
involving a lot of things. I'm asking for those things that you have. That's perfect. Why, what we have.
Doing this exercise is not for any other reason. I'm trying to find out why the money is not coming to us, why the center is not releasing them. That is the only reason. Otherwise, I can easily dispose of this matter. That it should be verified. But will that stop? Will that help you? That's what I'm thinking. So what will do is with the one last time. Thursday, you all sit. You please bring your technical people. That's it. One, two, you, Mr. Pro, please bring your technical person. Please come. What time should they be? Or why here? Somewhere else. They can meet on a Wednesday also. Yes, you all, you see, better to, you see, because that's the one thing to that. So please meet on Wednesday. Stay at 2 o'clock, or somewhere at 3 o'clock or wherever. Then you all come again on Thursday, because one day you might not clarify everything. So that on Thursday we will pull up all the numbers. Okay, so better you can. So all the reports will be available. Then 4:30. On Thursday they will come. Wednesday, when did you go? When did you? Who in your bring? Yes. What about you, Mr. You are for what else? Particular what to do? Or is Chaudhary a spokesperson? Huh? Huh? This is another thing. Let them first. No, but before that, let them find out the procedure and how to make the payment. See, where is the bottleneck? Let us at least clarify that. Because otherwise, what I'm looking at is maybe what will happen if probably you'll be filing contempt cases. So that is why. Let us see why the payments are not being made. I think number of persons are still there, not are there. Sure. All those, all stuck up. So there's no point passing an order. It's not implemented. So let us see why it's not being implemented. No. Okay, sorry. Sorry, sir. If you don't want to come, you can relax. It's okay, Mr. Go, is it? Wait, wait is there, what time? Huh? 10:30. 10:30, Mr. Is there? Yes, anything to say, Ms. Barwa? We have got also some cases. Huh? Okay, anything to say? Okay, okay, we see. You see, it's like I said earlier, it's not that I cannot dispose of the matter in that light. But then, and there was a earlier order passed in a bunch of cases. You all know that. Now, all those cases now have turned up in the contempt docket because they're not complying. So we have got to find a way, madam, to please sit down and devise a method as to how to make the payment. You know, I mean, otherwise there are so many persons lined up. I mean, today itself we have got how many? Around 60 cases. So we have got to clarify this. So we have got to, oh, very good, very good, very good. Then after they get their payments, they're going to have a big party. Okay, right. Huh? I think so. Here's the counsel for the party. Mister, what is your name? Nayan Jyoti Goswami, Executive Engineer, uh, Water Resource Division, Department, Government of West Bengal. Has also assisted with court in respect of the non-payment of contractual dues of the petition. He submits that 141 schemes had been approved by the Government of India for flood control under the 11th and 12th plan. 100 schemes were recommended under the 11th plan and 41 schemes had been recommended under the 12th plan. At 12th plan. So we submit that in respect of the 17th scheme that has been the issue with regard to non-payment of contractual fees, the value of the 17th scheme pertains to no, the value that the 17th scheme was rupees 341 crore. The 17th scheme were put into play in the last financial year of the 11th plan, and it was categorized as spilling over to the next plan, that is the 12th plan. So, sir, he submits that the ratio of payment of the cost of the said scheme was 90/10, which was later changed to 80/20 after March 2015. He also submits that administrative approval had been given for 341 crores for the 71, for the 17th scheme to be implemented. While the Ministry of Water Resources, which has been renamed as Ministry of Jal Shakti, has approved only 191 crores out of the 341 crores under the 11th plan. So, now he further submits that the center has released 130.41 crores and the state has released 45.96 crores. So subtract for the 17 scheme, rupees 176.6 point 37. Okay, 0.37. 0.374 has been paid out of 341 crores. So out of 191 crores, out of 191, so by thereby leaving a balance of approximately how much? Approximately 15 crores, 14 crores, how much? 14 crores. Now to calculate. Leaving a balance of approximately 14.63 crores. As the 17 team totaling 341 crores was categorized as spilling over to the next plan. The total 341 crores would have to be paid for implementing the 17 next plan, which they have Learned Council for Learned TDC submitted. A meeting would be held on tomorrow, 25th, 25, at 10:30 a.m. along with the executive engineer of the Water Resource Department and technical person of the central government from the proper board for tracking out the problem as to why the center has not been releasing its share of the fund. This is a matter on. So you do that meeting and let us copy of the order be furnished, or you upload it, download it. At the end of the day, it will be a very simple order, but you have to give me, please write it down, huh? The meeting minute the meeting that you hold on Wednesday, please have a meeting minute made and please make a resolution as to how to break the deadlock with regard to the payment of the balance amount. Okay, some kind of resolution, and then we will incorporate that. We will dispose it off.
Copy of that.
It will be even here. You're always Xerox. So stuff. So what is this? Now this.
My lord,
Have you given a copy to the other side?
my lord, I just now I have. Compliance, my lord, one technical team was sent, my lord. Thereafter, my lord, was found, my lord. The first part, my lord, we cannot admit because that, my lord, was not non-permissible work. And the second part, my lord, the technical team have went there, my lord, already accessed. And as per that report, my lord, we have communicated to district commissioner day before yesterday, my lord, to comply the report. Therefore, this matter may be taken after vacation, my lord. We will take compliance.
Now, uh, which scheme cannot be done?
First one,
Which one?
in my instruction, my lord,
Right.
raise platform at Lahangaon near Namgad under.
Okay, okay, right. There's that. The done asking for the respondent. Respondent submit that the scheme will cover the raised platform at Lahan down near Namgrab under MGNREGA 2021-2020 is non-permissible under MGNREGA as per para 7.2 of the annual master circular 2021-20. This is here. Accordingly, no payment can be made to the taxpayer. Next up. However, with regard to the scheme, namely earth filling land development at proposed site of PMAY-G colony of number 2 Kailamari under MGN REGA for the year 2021-22 rupees 25,22,560 rupees and also working estimate amount of scheme, namely raised platform. What is this again? I'll cut that. The accordingly submits that the Commissioner, Panchayat and Rural Development Affairs, by letter dated 21/6/2025, has directed the District Commissioner of DPC MGN REGA, Sakipur, to take necessary action for compliance with the order dated 28/2/2020, passed in WPC number 1024/20. Review the above letter dated 21/6/2025, issued by the Commissioner of Chat and Rural Development and Sam to the District Commissioner from DPC MTN REPA Sakipur. It is here. The matter we listed on what do you want? You have a copy of that letter, you can take photos. So take it from him.